If you're involved in North Carolina real estate at all, then you have probably heard or even used the phrase 1 to buy, 2 to sell. Hey everybody, I'm Tiffany Weber. I'm a North Carolina real estate attorney in the Lake Norman area, and today we're going to talk about when does my spouse need to sign during the closing process? And the answer to that, you may not like it, but the answer in North Carolina is almost always. So here's a real life example. About 12 years ago, when my husband and I were engaged, he bought our first house. He was the only borrower. He was the only person on the deed. And we got married a year later. And then 5 years after that, we sold the property. Now, I never went on the deed, and that was not the greatest idea. I can explain that in another video, but at the time I was not a real estate attorney. I didn't know any better, so I never went on the deed after we became married. But I still had to sign all of the closing documents, even though I was not a borrower, I wasn't ever put on the deed, none of that. And we got married after he even bought the house. So why did I have to sign at the closing? You may hear that story and think, there is no way that's right. That doesn't make any sense. You're misremembering it. But if you're involved in North Carolina real estate at all, then you have probably heard or even used the phrase 1 to buy, 2 to sell. And that's because in North Carolina, a spouse acquires a marital interest in real property regardless of when the property was acquired. So whether that was before or after marriage. This is because of your spouse's right to inherit in your estate. So to get rid of that right altogether with respect to the property that you intend to sell, your spouse must join in the conveyance documents. This can also be true when you're buying property. Now, if you're paying cash, generally you can sign all of the documents without your spouse having to sign anything. But if you're getting a loan, that's a different story. And also to be clear, even if you're paying cash and you're signing without your spouse on the purchase, then your spouse will have to join you whenever you sell the property and sign all of the documents. But if you're getting a loan to buy the property, then the lender's going to require that a deed of trust be signed, which your spouse is going to have to join in, and your spouse will also have to sign any of the other documents required by the lender to secure their interest in the property. There are exceptions to every rule, of course, but in this case, all of the exceptions require legal documents be signed by your spouse that will relinquish their rights to the property or otherwise give you permission to sign without them. Those types of legal documents can include, but aren't limited to, prenuptial agreements, postnuptial agreements, separation agreements, free traders, and sometimes even a prior deed from your spouse to you conveying away their marital interest in the property. In short, there is no exception that I'm aware of that would allow you just to simply sign the documents without your spouse knowing in any way, shape, or form. Remember, this is the rule in North Carolina, and North Carolina is known for having some interesting laws as it relates to spouses. So if you're in a different state, this is not going to apply to you. So you need to talk to an attorney in your state. And even if you are in North Carolina, every situation is unique. So talk to a real estate attorney about your situation to figure out what exactly steps you need to take to either have your spouse sign or not sign at the closing of your real estate. I hope that was helpful to explain when your spouse needs to sign. Like I said, it's almost always. And we like to put out videos just like this one, all about real estate law, different topics in real estate in North Carolina. So go check out my channel if you are interested in these subjects. We'll see you in the next video.